All right, it looks like we're set. We doing a little bit of seat switching. It looks like, but we like to adjust and adapt on the fly. Welcome everybody to Bressler, Amory, and Ross's fourth edition of our webinars for the COVID-19 and the Workplace series. This week we're going to be talking about mitigating employment law risk. We've got a large swath of our employment group located in Alabama and New Jersey on the conference today. We have a lot of material that we're going to cover, so I'm going to turn it up pretty quickly. Just wanted to remind everybody that we have an upcoming webinar next week. It's going to be talking about creditors' rights, potential bankruptcy, pitfalls, and tips where we're getting a lot of questions from clients about modifying terms of transactions, things like that. So we thought it was a relevant topic to discuss with everybody. If you want to watch any of the prior series of the webinars that we've had legislative developments, we've had cyber security and virtual practice of law so far. Those are all available on the firm's website. And they are all on our COVID-19 task force page. Matthew, I'm going to turn it over to you, and I think you're going to talk about what the overview of what's happened since the last time that we've presented.
That's right. Thanks, Nick. Glad to be with all of you today. We want to spend the majority of our time on the topic managing risk in the workplace. And to do that, we've divided up the current workplace climate into what we view as three buckets. The first bucket includes the telework workforce, and Rima Hartman is going to be giving us advice and best practices on that subject. The second bucket includes those essential employees who are still going to work, and Stuart Roberts will cover concerns arising in those employment settings. Carol Miller will talk about the third bucket, workplaces reducing or eliminating their workforce. We've got Justin Condit, who's going to share some New Jersey and New York specific insights. And finally, Nick is going to share a few things we all need to know about the Paycheck Protection Program. But before we jump into those areas and those buckets, we want to remind everyone some basics on the federal leave laws. We first talked about those 3 weeks ago on March the 25th. It's only been 3 weeks, but a lot has changed during that time. New laws have been passed. The number of confirmed COVID-19 cases in the U.S. has grown from 70,000 to 600,000, and shelter-in-place orders have become the norm. There's now guidance that clarifies some of the questions about coverage and eligibility relating to those laws. The big law that we talked about on March the 25th that came in is the Families First Coronavirus Response Act. It has two paid leave provisions. One is the emergency paid sick leave, and one is the emergency FMLA. The emergency paid sick leave covers private employers with fewer than 500 employees, and that's determined at the time that the employee's leave is to be taken. However, it exempts certain employers. That includes healthcare employees, emergency responders. And the guidance issued defining healthcare providers and emergency responders is broad. We've had a lot of questions about that. For example, the guidance includes employees who ensure the welfare and safety of our communities, and those who provide essential services related to the public health and well-being. So if you think that you may qualify for that exemption, take a look at the guidance that the Department of Labor has issued. There's also an exemption for businesses with less than 50 employees if complying would jeopardize the viability of the business. And that exemption is available when the leave is requested because a child's school or place of care is closed. And there's specific criteria that the DOL has provided, and employers should document how they meet that criteria. One question we have received concerns the shelter in place or stay-at-home orders and whether they are actually quarantine or isolation orders under the Act, and the DOL provided guidance on that. For purposes of the Families First Coronavirus Response Act, a quarantine or isolation order includes shelter-in-place or stay-at-home orders issued by any federal, state, or local government authority. But it's important to remember that the employee must be unable to work or telework to obtain the leave. You're not entitled to the leave simply because you're subject to a stay-at-home order. We're going to move on to shutdowns and furloughs a little bit later in the webinar, but as to the emergency FMLA, it has similar coverage provisions and definitions for exempt employers, but the key difference in the emergency FMLA and what we'll call the regular FMLA is that employees are covered if they have worked 30 days. Employers need to document the request and the decision to grant or deny leave. And the guidance provided states that what you need to document includes the name of the employee, the date the leave is requested, the reason for leave, and a statement from the employee that he or she is unable to work because of the reason provided. Intermittent leave is also available under the emergency FMLA. Now, we've provided a slide on the COVID-19 related tax credits, and if you are providing leave under this law, you need to obtain those credits. Guidance is provided on the IRS website, and we've given a link to that, the web address on the slide. We ask that you take a look at that. It's important to remember that in addition to the federal paid leave laws, there are numerous states and cities that are enacting laws related to the pandemic. Now, we can't cover all of those, but one of the most recent is New Jersey. Justin, can you shed some light on that new law?
Yeah, so just yesterday, New Jersey enacted a series of new laws. One of those is the amended the States Family Leave Act, and the new bill expands the act to include time off for employees who need to care for a sick family member due to an epidemic of communicable disease, a known or expected exposure of the disease, or to prevent the spread of the disease. It also expands the act to cover employees who need to care for a child due to a school closure or a place of care closure caused by the epidemic. This is all very new. It just came out last night, so we hope to send out a client alert addressing all these issues in the next few days.
Great. Thanks, Justin. So we want to move on to our buckets of employment, and we're going to begin with the remote workforce. We've got to do a little bit of shifting around here due to some technology issues here in our office, but Rima is going to share with us her insights on the remote workplace.
Hi, everyone. Sorry for the technical difficulty, but I do want to talk with you today about teleworking programs, which are obviously becoming more and more prevalent in this COVID-19 era. When employers are trying to implement a COVID-19 telework program, they have to balance a number of considerations, and sometimes those are in conflict with each other. I see three primary factors that people are trying to work within. The first one is you're trying to, as a company, you're trying to maintain your operations as best you can, keep people employed, keep things moving forward, and ready yourself to resume normal operations when all of this is over. At the same time, you're having to meet employee needs, and you need to try to be as flexible as you can. You're trying to take care of your employees, keep them, build their loyalty so that they're there for you when you are able to resume normal operations. They need your understanding. They're going through unprecedented times. They're experiencing possibly isolation, economic anxiety, maybe they have health concerns or they've lost someone. So it's important to be understanding of employees. It's also important to be flexible with them. If any theme is emerging most clearly from the governmental guidance that's coming out these days, it's that the government wants employers and employees to work together toward a flexible, plan that will work for each person. So individual circumstances may vary and they'll change over time. And I liken this to the interactive dialogue that's required under the ADA. All of the employers are used to doing that. Engage in a similar interactive dialogue now as it relates to COVID-19 and what each employee may need as part of the remote workforce. The other thing I would be remiss without saying, the third factor, is that you have to guard against abuse. Unfortunately, it is a reality that some employees will try to take advantage of the situation. You know who they are, and there's a lot to work with right now in terms of potential abuse. So with those factors in mind, it's important, if you're going to have a remote workforce, to establish a teleworking policy. Maybe you have one already, but I would be willing to bet that if you do, it's narrower than what you need now. You might want to create one that's more specific to this situation, broader, more comprehensive. As an aside, we've had inquiries from a number of employers about establishing epidemic/pandemic policies. Most employers have policies for emergency closures relating to things like inclement weather and that sort of thing, but this is different, as everyone understands. So you may want to consider that. We can help you with that if you need to do that. Once you've decided that you're going to have a remote workforce, you have to determine who will work remotely. If you don't have enough work for every single person on your staff to work remotely, then there are choices to be made. Generally speaking, if you can allow employees to self-select, just like in any other employment-related matter, when it's voluntary, it goes over better. So maybe you have people opt in, maybe you have people opt out, but in general, I think if employees can self-select, that's a good idea. But maybe self-selection won't work. You know which jobs are critical, you know which jobs are not, and within those critical jobs, you know who your best people are. So, you may want to make those selections yourself. If so, if you're going to be making the selections as to who gets to work or who gets to be temporarily laid off, please be careful about the appearance of discrimination. Just as you would in connection with a reduction in force, look at it from the perspective of a disparate impact. Ask yourself, have you selected all of the younger workers to telework, for example, on the assumption that they're more technologically, capable? Have you made any assumptions about the responsibilities of working mothers that may be problematic? And ask yourself if someone could look at the data of who's working and who's not and make an argument that there's been discrimination. And then once you've identified who will continue to telework, who will continue to work, albeit remotely, then ask yourself, what about everyone else? Are you temporarily laying people off? If so, then that's an issue that Carol will be discussing later in our program. If you're permanently laying people off, then that may have implications for you in terms of any PPP loan that you're getting, and that's something that Nick's going to cover later in the program. For those people who will be working remotely, your responsibility is to make sure that they have everything they need to work from home. So the equipment that they need, the cybersecurity and other security measures need to be in place. Remember that you are still applicable to you are still subject to applicable regulations, and make sure that you pay attention to cybersecurity and privacy concerns, which I know were covered in a prior webinar in this series. The next thing is you're going to be managing your remote workforce, and I think that if nothing sticks with you today other than this, I would say communicate, communicate, communicate. Remember that teleworking equals working. They are working. So that means communicate to them that company policies apply. Their duties have to be performed, or if some of their duties can't be performed in a remote fashion, identify those that can and that are expected to be completed fully. Their time, if they're non-exempt employees, their time must be recorded, and you need to provide a reliable mechanism for recording their time. Create structure and accountability for people working from home. Tell them what you're expecting in the ways of when they'll be online, what their hours will be, what you expect in the way of responsiveness, how you'll measure their performance and productivity, and make sure everyone understands that discipline is still an option. You're still running your workforce, so you still have all the tools available to you to manage employee performance. Paying teleworkers, all of the rules still apply. For exempt employees, unless you've entered into a new arrangement and you have a reduced salary for a lesser role, the rule still is that you can't deduct pay from an exempt person's salary for in a week when they have performed some work. The rule still applies that you're responsible for non-exempt employees to record their time and pay them overtime. That's something else you should communicate in advance. Is overtime authorized? You know, what will they need to do to get approval if they're going to work overtime? But you have to pay it if they work it, you know, even if they haven't gotten the approval in advance. You just deal with that failure to get approval as a separate matter, possibly disciplinary matter. And then there's the issue of your normal paid time off policies, vacation or sick leave that you have in place. If someone is sick with something besides COVID-19, then you can dock their sick leave for time that they're not working. If someone takes a day off, elects to take a day off or take a half a day off, then you can dock their vacation. So those rules all still apply. And remember, for exempt employees, you can dock their leave banks when they work a partial day or a partial week, but you can't deduct their pay. And the last thing on this slide is, you know, things feel a little loosey-goosey and it feels all informal, but I want to reiterate that all the old rules still apply, and that includes the cardinal rule of employment law, which is document, document, document. So if you have made an arrangement with someone for intermittent leave, document that. If you have spoken with someone about performance deficiencies or failures on the job, send an email about that so you have it. It may be a little more informal, but make your record. There are going to be variations of telework arrangements in this COVID-19 era. Some people will be working full-time from home. They'll be doing their whole job for their whole pay, and if they are allowed to go to the office sometimes, you need to make sure, just to pick up things or to be there a little bit, you need to make sure that you are making their office safe. And that's something that Stuart will be talking about in a little bit when he talks about going to work in this time. But other people may need to right-size their jobs, and they may need to be teleworking on a part-time basis. And that may be either because they have personal needs like childcare concerns where they're asking for a more limited role, or it may be because you have less work to offer them. If the employee says, for example, my husband and I are trading off with childcare arrangements, and I'll be working in the mornings and he'll be working in the afternoons, and you know, I need to take intermittent leave to cover the time when I won't be working. The Families First Coronavirus Response Act allows for that by agreement with the employer. And so that's another example, probably the best example I can give you, of this really important interactive dialogue that the law is asking of you. Make sure that the employee understands that for the period of time that she is off using the new FMLA, expanded FMLA leave, she's only going to be making 2/3 pay, but work with her, you know, if that's what if she brings you those kinds of concerns. But if instead it's the employer that reduces someone's hours because there's not as much work available, then that person that decision may trigger eligibility for unemployment benefits, which of course will vary state by state as supplemented by the federal government now. Now that's going to be tricky because I think, as Carol will discuss later, unemployment benefits are now in some cases paying people more than their regular job would pay them. So you have the opposite problem we had with intermittent leave and a reduced pay. If people are not teleworking and they're not working in the office, they're on furlough, an actual temporary layoff, or they're on a non-intermittent leave, then do not allow them to telework. They are not supposed to be working. And again, teleworking is working. So be sure that you're not requiring anything of people on furlough or on a full-time leave. And then I think we're all going to be receiving requests. Everybody's going to be anxious to get back to work when we're allowed to, but then that will wear off. And I think we're going to see more and more people requesting to telework as a regular matter of their job. And we may have opened the floodgates here to something, and I think employers should be at least thinking about whether they can integrate an expanded telework aspect to their regular operations, because you are going to be getting requests like that, and it's going to be hard for you to argue, no, we can't pull it off remotely. And so with that, I'd like to turn it over to Stuart, who's going to be talking about the essential workforce that's actually going to work in this coronavirus time.
Thanks, Rima. Stuart, real quick, before you get going, let me just interject the first code that we're going to have for the CLE credit for all of our attorneys who are tuning in. The first word is going to be families, and I will put that in the notes, which can be toggled on the bottom left of, or bottom right, excuse me, of the screen. And with that, Stuart, all you.
All right, thanks, Nick, and thanks, Rima. As Rima mentioned a moment ago, I'm going to be addressing those employers who have essential businesses who have employees who are still showing up at the facility to work. And as you would expect, the overarching goal should be for any employer with employees in the workplace to protect worker safety. That should be your first and primary goal. However, from an employment law perspective, there can be some issues that arise if an employer is overly zealous and doing too much to protect the workforce. That can lead to violations of federal and state non-discrimination laws, principally in this context, the ADA. And the ADA, the Americans with Disabilities Act, is relevant in a pandemic situation, COVID pandemic or other pandemic, in several ways. First, it limits an employer's ability to make disability-related inquiries. It also prohibits, in certain circumstances, medical examinations of employees. It prevents you as an employer from excluding people from the workplace if they have a disability, unless they pose a direct threat. And finally, the ADA imposes on employers obligation to provide reasonable accommodations to allow workers to perform their jobs. Fortunately, shortly after the pandemic was announced, the EOC issued guidance for employers that should help out those with workers currently at work in trying to make sure they navigate some of these very complex issues. And instead of issuing new guidance, they really just dusted off some guidance they issued back in 2009 with the H1N1 virus pandemic, and then made some changes to custom tailor it to COVID. And so the first slide, I mentioned the EOC has relaxed certain rules in light of the pandemic in order to protect worker safety. Probably a better way to say that is that the EOC has recognized that because COVID-19 is so dangerous that in many contexts it automatically imposes a direct threat, and direct threat finding allows or kicks in several exceptions under the act that allows employers to engage in conduct they ordinarily would not be able to pull off. And on the slide, I've listed a few things that, again, that are that employers can do. The EOC has clarified that employers can do in its guidance. The first one is take employee temperatures. Under normal circumstances, taking temperature of an employee would be considered a medical examination, and medical examinations are, as I mentioned earlier, employers are constrained from giving those except for in certain circumstances. Fortunately, one of the times you can engage in medical examinations of employees is if there is a direct threat. And by allowing, or by saying employers can take temperatures of employees, the EOC has conceded that the COVID-19 virus, the coronavirus, poses a direct threat, allows for those medical examinations. So if you're an employer who's actually doing this, you're taking temperatures, you certainly need to make sure any records you've taken, any logs of temperatures are maintained confidentially, because those rules still apply even in a pandemic situation. The second thing is that you can ask applicants or current employees whether they are experiencing some of the symptoms that the CDC has acknowledged or has recognized are attached to the coronavirus. And those include, at the risk of sounding like a NyQuil ad, fever, fatigue, cough, sneezing, aches and pains, runny or stuffy nose, sore throat, diarrhea, headaches, and shortness of breath. And so you can ask questions about symptoms, but you are absolutely prohibited from asking disability-related questions. You can't, for example, ask an employee or groups of employees if they have high blood pressure, or if they have diabetes, or they have other lung conditions that might be otherwise considered a disability, because you're asking direct disability-related questions. If your questions stick just to the symptoms that are listed on the COVID website. I just read them off. You'll be in much better shape. And as I mentioned before, any information you obtain in response to these questions, you need to keep confidential at all times. You can send employees with COVID or you suspect to have COVID-19 home. If they have symptoms that I just mentioned earlier, you can send them home. There's, again, the EOC is clear that even disabled employees who pose a direct threat in the workplace do not have the right to be in the workplace. For applicants, if you have a job that needs to be filled immediately and the applicant in the course of a post-hire medical examination or questionnaire admits that they have COVID-19 or they have COVID-19 symptoms, the EOC says it is fine to even withdraw that job offer because you need that person immediately. On the flip side, if it's someone who could fill a role in 2 or 3 weeks, you're not supposed to rescind their job offer simply because they've tested positive or they've exhibited those symptoms. So you need to hold that job open. This is common sense, but you can require a fitness for duty note from a physician for someone who's returning from COVID-19 back to work. That seems to be common sense, but the EOC has included that in its guidance. And finally, employers, again, always have the obligation to accommodate employees with disabilities. And there could be numerous different types of accommodation depending on the circumstances. If you have an employee with a latex allergy, you might want to give them non-latex gloves. You might want to relocate someone's workstation if they have some disability that makes them more susceptible or vulnerable to COVID-19. Move them away from other people if you can, or prevent them from, keep them from working with customers. It could be telework, as Rima spoke about earlier. That could be an option for people with disabilities. So those are the things that the EOC has been very clear employers can do. And one other question that will come up, and this is also addressed, it's not in the outline, is what about if we come up with a vaccine? If there's several different entities working on that, hopefully that happens soon. Can we force employees to take the COVID vaccine if it becomes available? And the answer is the same as it would be now. The answer is no, and that for a couple of different reasons. One, if you have under the ADA, if you have an employee with a disability who might be harmed by taking a vaccine, you certainly don't want to force them to take a vaccine that could impact their health. Also, from a religious discrimination standpoint, some people, part of their deeply held religious beliefs about they're not supposed to take vaccines, and so you couldn't require them to force them to take a vaccine. You can certainly encourage it. You can strongly encourage it. You can pay for it. You can do all sorts of things to try to get that, to get the employees to take vaccines. But mandating that is certainly verboten. Okay, moving on from the EEOC, OSHA, which when you think about worker safety, certainly the first agency you probably think about is OSHA. They have also issued guidance to employers to address concerns relating to COVID-19 and to protect workers in this very dangerous time. I included in the slide the link to the actual publication. It's about 30 or 40 pages, and we don't have time to get in all the details on a call like this, but I would encourage you to take a look at that. But in essence, what OSHA is doing is telling employers what it expects of them for employees who continue to work in the workplace. And the biggest thing that OSHA stresses is it wants you to have a plan and wants you to think about these issues in advance and go ahead and try to assess and address potential dangers associated with the virus before those issues arise. And I think Rima mentioned earlier, it would be wise to have, especially now that we've had 2 pandemics in the last 11 years, it'd be wise to have an infectious disease response policy on hand that you could, again, dust off whenever the next illness pandemic rolls down the road. But as part of this planning, one of the things they want, OSHA is very clear on, is employers should be very keen on identifying sick employees and sending them home. Employers should encourage their employees to self-monitor for signs of COVID-19 and to report if they feel like that they might be, they've either been exposed or they're suffering symptoms from the disease. Employers should designate one or more people as the persons to whom such affected employees need to go, just so they know where they need to go if the issue arises. And employers should develop policies and procedures beyond reporting, but also should have a place for employees to go, an isolated area if they believe that they're suffering from symptoms of coronavirus. So the other issue, the biggest issue that OSHA addressed was identifying and addressing potential sources of exposure to the coronavirus in the workplace. They want employers to look at your workplace. Where do workers work in close proximity to each other? Where do they work close to customers? Where do they work close to members of the general public? Those are the areas that you need to focus on if you're an employer to try to prevent infection. Also, are there bottlenecks in your facility? Do you have a lunchroom, for example, where employees congregate? Do you have an exit or a time clock where employees at the end or the beginning of their shifts tend to congregate in kind of a very, very dense area in terms of employees? You need to come up with ways to address that. Certainly, you can come up with different types of controls that depending on the severity of the risk, the higher risk employees, you certainly want to impose more controls than for those who are much less likely to be exposed. The guidance also goes into different risk categories and it describes low, medium, high, and very high risk. I won't get into that in any great detail, but as you can imagine, low risk employees, those who have very little contact with co-employees or with with customers, those who don't deal at all with COVID-19 related issues. Then you have the high-risk employees, your frontline responders, your medical providers, nurses, people of that nature. And so in assessing what sorts of controls you need in the workplace to protect employees, you certainly need to assess what kind of risk level that they have. And those controls, without going too deep in detail, again, this is all on the OSHA website. Sneeze guards, we've seen those. If you've been to a grocery store in the last 2 or 3 weeks to a month, you've probably seen sneeze guards there. I'm sure they're in other workplaces as well. Ventilation system, air filtration, make sure your air is flowing through very well. The administrative controls, making sure employees are as far apart as they can be to perform their jobs. If you can stagger shifts, stagger start times to shifts, staggered lunch schedule so that you have fewer people in those areas where employees congregate, that makes sense. If you can add a shift or add additional shifts so that you can spread your employees out, that makes sense. PPE, OSHA requires PPE where it's necessary to protect employee safety, and that personal protective equipment in the context of Corona can include the things we've seen, gloves, certainly face masks. You've seen those if you've been out to pick up to-go orders. And then things like respirators for people who are on the front lines, and we've heard all about that in the news as well. Finally, OSHA, is telling employers to do common sense type things, such as train your employees or remind them to wash their hands. Don't touch their face, which is something I've probably done 15 times during this webcast. Avoid close contact with others. Stay home. If you're sick at all, if there's any question, stay home. If an employee presents themselves as sick, send them home. Err on the side of caution as always. And it'll be helpful. OSHA actually released last week a poster. It's on its website titled 10 Steps All Workplaces Can Take to Reduce Risk of Exposure to Coronavirus. I would encourage you to find that on the website. It does have additional steps employers can take. And I think this, again, goes without saying, but it's very important that your employees have adequate hand washing facilities. They need to, if OSHA comes in, there's an employee complaint, OSHA comes in and you don't have enough sinks, enough soap for the workforce, or enough different areas for them to wash their hands, that's something they're going to hit you on. They're very clear about that. So finally, I kind of wanted to run through some common scenarios we've seen from clients and just in general relating to coronavirus in the workplace, things that have come up, and give our best kind of guidance on how to address these issues. And it's kind of a progression of issues. And the first scenario is you have a worker in your manufacturing facility, and you have a shipping employee who presents with a fever or cough or any of the other COVID symptoms. What do you do from that point? And the first thing you need to do is you need to talk to that employee. You need to get information. You need to first isolate the employee away from the rest of the workforce. You can ask them about their symptoms, get as much information as possible so you can make decisions about whether to send them home. Avoid asking disability-related questions. I covered that earlier. And ask them for permission if they do show signs of infection. Ask them for permission to identify them to coworkers who might have been affected, or working close by them, so that you can inform them. Conversely, if they don't give you permission, you really need to avoid giving names out, and we'll cover that a little later. And I'm kind of running low on time, so I'm going to go through some of the rest of this pretty quickly. With coworkers, you need to ask the affected employee who's that worker been around in the last 48 to 72 hours before being infected or showing symptoms, rather. And you need to get those people who've been within 6 feet for a prolonged period of time. You need to get those people out of the workplace until you can assess what their exposure might have been. You certainly need to clean the work environment. The CDC has very detailed directions on the types of chemicals you need to use, what you need to do, when you need to do it to make sure that the workplace is safe. Okay, the next part of the scenario is that worker you send home now is tested positive for COVID-19. There are certain communications you need to make. First, you need to let the employees at your facility know that you do have a COVID-19 positive test. Again, you should not give the name of the employee unless you have permission to do so. And finally, we've had employers ask them, are we supposed to tell the CDC? Are we supposed to tell local health, state and local health agencies about this? And the answer is really no. I think the health provider should be the person providing that information. And finally, well, on this scenario, you have employees who have not been exposed to the virus, who weren't in the shipping department, have no reasonable belief that they've been exposed, who call in and say, I don't want to work. I've heard about this COVID-19 diagnosis and I don't want to come in. And there's not an easy answer to how to deal with that. I can tell you what you can do legally, and then we can discuss what you should do. But under OSHA, which is the primary federal law that discusses workplace safety and what employees can do in response to that, an employee has to have a genuine belief that an imminent danger exists, that they reported that to the employer did nothing about it, that the average person on the street would also be similarly of the belief that an imminent danger exists, and that it's too late to go request an inspection, the harm is too imminent. So under OSHA, most of the time the employees not working in the shipping department aren't going to have a leg to stand on. However, under the National Labor Relations Act, if you have a group of employees who get together and complain about this and complain about exposure in the workplace, you could have concerted activity which would give rise to protection under the NLRA. And that happened recently at an Amazon facility in Staten Island. And in fact, an employee kind of organized a walkout, onto being terminated by Amazon. And I'm sure we'll see an unfair labor practice claim come down the road. So what should you do? I think you should consider if employees don't want to come to work, can they work remotely? If that's not possible, talk to them about using PTO and sick leave at least for the time they have it. You might even want to consider expanding their sick leave and PTO time. Let them go into a negative number that they can make up later if that makes sense in your circumstance. But you always have to balance all of this with the very real notion that employees not showing up for work can cripple your business. So this is not a one-size-fits-all approach, but these are the sorts of things you need to think about. And finally, what if you have other employees who become infected? Particularly those who work in close proximity. The first issue that comes up is workers' compensation. If employees get hurt in the workplace or become sick in the workplace, most states will allow them to collect compensation for that. Under federal law, the DOL has already said workers who are working on the front lines or working in areas of high risk, we're going to assume that the reason they got COVID-19 is because of their work and they're going to be eligible for benefits. Some states have passed some laws or similarly have said that we're going to assume causation for people in high-risk industries. However, some states have law that say ordinary diseases of life are not covered under workers' comp. So you really need to look at, in a particular circumstance, did the person get it at work, or were they just as likely to get it elsewhere? And if they're only going home and coming to work and no one else is sick at home, they're going to have a pretty good argument they got it at work. Justin, I think you had some things to add about New Jersey and New York developments in workers' comp.
Yeah, very quick. Two developments in New York and New Jersey. New York expanded the definition of disability under its workers' compensation law. This now covers the inability to work because of an order of isolation or quarantine. And then New Jersey has not amended its law yet, but there is proposed legislation out there to expand its workers' compensation law to cover certain essential workers, similar to the federal change in the law. And I think we can expect that in more and more states going forward.
Suits filed, wrongful death lawsuits. One filed against Walmart in Chicago, where 2 employees were exposed and died, and the employees alleged that the management knew that this was rampant throughout the store. We'll see more of that as time goes on. And then I mentioned earlier OSHA citations. If you're not taking the steps we've discussed earlier, employees complain about that, and there have been many complaints, thousands of them to this point. OSHA can knock on the door and issue violations either under the general duty clause or under their PPE regulations at a bare minimum. With that, I know we're a little over on my time, so I'll turn it over to Carol Miller to discuss the next step we have we're dealing with closing down workplaces and furloughs.
Hi, thank you. So talked about workplaces that were operating remotely and the unique challenges with sort of distance working, and Stuart just talked about the particular challenges for essential businesses who are trying to continue their usual operations live. My part is to talk about the sort of last type of workplace, which is the disappearing workplace. A lot of employers now have no choice but to discontinue or scale back their operations, at least temporarily. They're not set up to work remotely with their employees, and they're not an essential business. So basically what we're talking about, think about, you know, your hairstylists, your manufacturers of non-essential goods, retailers, workout facilities, etc. For those businesses, what we're seeing is the name of the game right now is to survive financially until they can resume operations. And the questions that we're getting from employers relate basically to how they can best eliminate labor costs right now in the short term without running afoul of employment laws, and also how to do it in a way so they can quickly gear back up once they're able. The first focus is usually how to reduce the headcount. Most of the employees for these type of businesses will not be able to work remotely, so they need to be laid off or furloughed. Employers who are facing that choice are generally picking to furlough or selecting to furlough employees as opposed to laying them off, and there's some advantages there. First, obviously you have a ready-made workforce when it is time to go back. You will avoid the costs of sourcing, hiring, onboarding these employees, and when you're able to resume operations. Furloughing also helps avoid WARN liability, which we'll talk about in more detail a little bit. It's not a mass layoff under that act. If it's a temporary layoff of 6 months, or it's expected to be a temporary layoff of less than 6 months. Furloughing also, right now, as Rima touched on, the unemployment there's the federal stipend, there are state supplements, so that there's a real cushion for employees who are temporarily laid off. In fact, in Alabama, if the employee right now was earning under $22 an hour, they're actually making more on unemployment right now, which is leading to some other challenges for workforces that are trying to continue. I don't know if you guys eat as much pizza as we do in our house right now, but every pizza box has a big flyer on it, you know, begging people to be drivers and managers, and I think that's part of the problem, is sort of the lower paid workforce. They have been laid off. It's harder to go and get a job when it's so lucrative right now. Furloughing, instead of laying off employees, also avoids COBRA notices, and you can generally keep these employees on insurance. One thing to be mindful of as an employer is you need to check your plan. Some of these plans have embedded in them a requirement that employees work a minimum number of hours to be eligible for coverage. So you wouldn't want something to happen and then insurance later to say that they weren't covered. The good news is most insurers have now come out saying that they're waiving this requirement for COVID-19 furloughs. I think it's still important to confirm that with your plan administrator and get that representation in writing. So once you've decided as an employer in this last category that you're going to furlough employees or lay them off or lay some of them off, the next issue is the selection process. And as Rima mentioned, all adverse employment actions are subject to later challenge, and it's important even in these circumstances that you're using objective, consistent, defensible criteria in selecting who stays and who goes, even for a temporary measure. A lot of employers are using, LIFO, last in, first out, or eliminating everyone in certain job categories, which is easy to defend. Now that said, you as employers are having to defend using an objective basis, which is easier to defend, with more subjective basis, because these employees who are remaining, are going to be less supervised. They need to be able to work independently. There will certainly be reasons to use more subjectivity in deciding who you're keeping when you're getting down to a skeletal crew. So after you have selected and you've laid off temporarily or furloughed employees, these same employers, we're getting a lot of questions about, they still need to do cost cutting even beyond that. Again, their revenue is down to nothing. They have liabilities with leasing spaces, et cetera, other bills. So we're getting a lot of questions about how do I, even with retained employees who are working less, how do I cut labor costs there? Important thing to keep in mind as employers, if you're doing cost cutting on salaries, is you can't reduce salaried exempt employees based on reduced hours. Salaried employees, of course, don't earn overtime when they work over, so it goes. You can't ask them to take less when they're working less. Under the FLSA, to maintain the exempt status, you have to pay salaried employees full salary if they worked at all, any work, and the designated 7-day work week. So with that said, what a lot of employers are doing is you can, as an employer, just cut salaries across the board. So say, for example, you're cutting salaries by 20%. That can apply to salaried exempt employees, but it's important that the reduction is not tied to the hours worked. You can't reduce pay 20% because you tell them they're going to be working 20% less, for example. You should maintain and should be clear with employees that they, especially management employees, that they are expected to work as much as needed. Obviously, it may be a lot less right now. It may gear up in the future. You may have differing demands on different weeks. But reductions that are simply cost-cutting measures can still be taken even with salaried employees. When you are cutting costs or salaries temporarily or permanently as part of these measures, also want to flag for you, be careful that you don't cut the pay of salaried employees below the 684 salary minimum for white-collar exemption. So, make sure that 20% or whatever cost cutting you're implementing doesn't take employees below that threshold. So many employers, even with these cost savings, will not survive the business interruption. I think we know that. If employers are forced to close some or all of their facilities or to permanently lay off employees, of course they need to be mindful of the Worker Adjustment and Retraining Act, Notification Act, WARN, as well as the state mini-WARN acts that require advance notice to employees and to the local governments. Federal WARN Act requires covered employees, which is generally 100 employees, those with 100 employees, to give 60 days advance notice of mass layoffs and plant closings. In general, mass layoffs are those, again, that are expected to last more than 6 months. So this generally would not apply to COVID-19 furloughed employees. Now, be mindful, though, in some areas of the country, if this does extend beyond 6 months, or it looks like the layoffs are going to extend beyond 6 months, you should be looking 60 days before or 4 months in at whether that notice should be given. There are also exceptions under the Act for the 60-day notice requirement. Most applicable would be unforeseeable business circumstances. You don't have to give 60 days notice in those circumstances. There's also an exception for any form of natural disaster and closures for a faltering company who fails because they were unable to get needed capital. Now, faltering company sounds like it would be helpful, except that it doesn't apply. It only applies if you giving notice to the employees would jeopardize your ability to get the funding to continue in business. So I think employers have a hard time saying, if they're waiting on, for example, some of the legislation, some of the relief under this legislation, that if I let employees know I was seeking that and gave them notice that they might close, that it would jeopardize that. So I don't think that one, we'll see a lot of that when some of these issues are litigated. I think the most promising exception is probably the unforeseen business circumstances, which are defined as a sudden, dramatic, unexpected action or condition outside of the employer's control. So while the pandemic, of course, was certainly unforeseeable, unless the layoff or the closure occurred immediately, one can argue it was foreseeable at least 60 days before you ultimately close. For example, if a business closes 6 months from now, it's going to be hard for an employer to say they didn't have enough foresight to give notice to the employees, particularly when this is ultimately viewed with the benefit of hindsight. So, in other words, the strength of that defense, the unforeseeable business circumstances, is going to weaken over time. Also, keep in mind as employers that all of these exceptions are affirmative defenses, which means the burden is going to be on you, so you need to proceed with caution. Also important to note that even if you feel very comfortable that you will fall within one of these exceptions, it doesn't mean you don't have to give notice at all. The Act still requires that you give notice, as much notice as practicable. So you still need to comply. It's just an issue of when. Obviously, I would err on the side of giving it, and if you think it's possible, as soon as possible. Justin, I believe there's a trend across the states to exempt the COVID-19 related layoffs and closures from WARN across certain states. Can you tell us a little bit about that?
Yeah, so certainly seeing it. And it started with California last month, and the governor of California actually issued an executive order suspending the notice requirements under their mini WARN Act. And then just yesterday, New Jersey enacted a new bill that excludes mass layoffs due to COVID-19 from being covered under New Jersey's WARN Act. Again, this is all very new, so we're still digesting everything from last night. But it's one important point to make before finishing up here is that these amendments to the state laws will not impact an employer's obligations under the federal laws.
So as an employer, if you are doing any kind of mass layoff or closing certain facilities or all your facilities, you definitely want to be looking at the state mini WARN Acts and at the federal, and perhaps the federal will get some relief there, but right now it's important that you do the analysis. Finally, as you guys know, Congress is working hard to prevent the businesses from closing as a result of COVID-19. Part of that is forgivable loans to the employers who are using it for labor costs. So how you manage labor costs and cuts can impact your ability to qualify for these. So it's important to be looking at that. Nick, can you talk a little bit about those, at least the Paycheck Protection Act?
Sure. Before I do, just wanted to give the second code for the CLE credits, which is going to be first. So it's families and then first. So those for the attorney seeking CLE credit, that's our code. So we're short on time, but the Paycheck Protection Program has been the single largest program that the SBA, the Small Business Administration, has ever undertaken. It has had a couple of iterations already. There's definitely some horse trading going on. There's definitely lobbying going on, and the program is continuing to evolve. And I think that you're going to continue to see evolution based on the fact that the impact of the COVID-19 crisis has really adversely affected larger organizations, smaller organizations, and everybody in between. And this is the primary means that the government is using, or the federal government is using, to help employers navigate this crisis. So I think on the slide here, the primary point that I would take is continue to monitor this, because if you're working for a larger company that does not ordinarily qualify for the Paycheck Protection Program, that doesn't mean that tomorrow it won't. And we saw that with about a week or so ago, the SBA came out with an alternative size standard test, which had defined a small business that would be eligible based on the maximum tangible net worth, easy for me to say, which is your total assets minus your intangible assets minus your total liabilities, not more than 15 million, and having your average net income after federal income taxes of the business for the 2 prior fiscal years not more than $5 million. So if you have a company which has more than 500 employees, but you think that you would fall within that, talk to your accountant and see whether or not that's something that would be available to your entity. There's also small business concerns defined in Section 3 of the Small Business Act, 15 USC 632. And I would go through them, but it has every industry, and they are wholly dependent on industry. Some, there's no size requirement based on the number of employees. Some, there's no revenue requirement based, but it's totally based upon the number of employees. So it is very specific to the industries. It defines what is in your industries. I know that we had a couple of comments about specific industries, but we can talk offline about which industry your entity falls within and whether or not you would qualify under the SBA's rules offline. But I don't think I can get through everything right now. For payroll protection, your amount of your loan is calculated by 2.5 times your average monthly payroll. And it does not include any salary paid to employees making over $100,000 that exceeds the $100,000. So you get credit for the first $100,000, but you do not get any credit if you have somebody making $200,000. You basically would have to have what was paid to them. The SBA originally also said that benefits paid to those employees does not count. It's $100,000 per employee. Then again, about 2 weeks ago, changed that and said, no, you can include those benefits for your employees. So again, things are evolving almost daily. There's a various number of industries that were originally excluded from the Paycheck Protection Program based on what they've done, anything that's federally illegal. So, for example, the medical marijuana industry right now is lobbying hard because they've been deemed essential businesses in basically every state where there is medical marijuana, which at this point is, I think about half the states have been deemed an essential business, yet those entities are not eligible to participate in the Paycheck Protection Program. So that's one thing where I think you may see some developments. Another industry that has been lobbying is in some states they have small taverns, bars where they have small gaming facilities. Maybe it's like a video poker or something like that. Well, because they had gambling, they weren't eligible for the Paycheck Protection Program originally. I saw Steve Mnuchin the other day talking about how they were looking for a fix to that to that problem so that those tavern owners were not excluded. So pay attention to the developments, and if you have questions, we're here and we're trying to stay on top of everything as it develops. Generally have CNBC on most of the time, trying to see if there's anything new happening, as we do field a lot of these questions relatively regularly. With that, I'm sorry. The last thing I had was with respect to any layoffs or furloughs, just know that your loan forgiveness is going to be reduced by that amount. So if you think, if your payroll is $2 million and you put in, if you received a loan for $5 million, but you furloughed or laid off half of your workforce, your loan forgiveness is not going to be the full $4 million. It's going to be reduced down to about $2 million because of the number, and I'm obviously using rough numbers, but it's going to be reduced in proportion to what your actual payroll is for the 8 weeks following the loan. So if anybody has questions on these things, please feel free to reach out to us and we can try to help navigate through the PPP issues. And with that, I think we are done, and we hope everybody enjoyed this most recent iteration of our COVID-19 webinars. Next week we'll be talking about creditors' rights. We'll be talking about how to protect yourself and or your entity, and how to navigate some of the issues that we see arising, as there's going to be workouts, there's going to be some creditors' issues, and there's going to be bankruptcies as a result of this pandemic. And we want to just help make sure that people are getting as protected as they possibly can be. Feel free to reach out to any of the members of the panel. We'll send a follow-up email to everybody with our contact information, and have a great day, and everybody stay safe.